Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. This video is for the professional ethics students. We are going to discuss the topic misappropriation of clients' money. While discussing the Bar Council of India rules, particularly rule number 15, I told you have to definitely protect the interest of the client. Maybe financial interest, maybe legal interest, whatever it is. You have to uphold the same interest of the client. And there are certain advocates who misappropriate the money of the clients. One such case is State of Andhra Pradesh versus Korapad Sachinana 2002. Right, this Korapad Sachinana is an advocate from West Godavari district. Sri Gutti Nagabhushnam, he was the plaintiff, that is, he filed an OS. I think OS number 1624/91 before the ADM in West Godavari district regarding some amount. So ultimately, Mr. Korpad Sachinana filed the wakalat under Order 3, Rule 4, and he has argued on behalf of the case. Ultimately, the matter was successful and the decree was granted for the decretal amount. And later, same Korpad Sachinana filed an execution petition, EP number 112/95, before the same court on behalf of Gutti Nagabhushnam. Things were right. And this decretal amount of 14,600, it has been paid by the JDR. So, Mr. Korpad Sachinana gave a receipt in the open court of the receipt of the amount of 14,1600. So it was recorded by the magistrate also, but the money did not reach the client. Korpad Sachinana did not give the money to Gutti Nagabhushnam. Later, Gutti Nagabhushnam directly appeared before the magistrate. The magistrate has seen the decretal order, has seen the order passed by him, and ultimately he sent a direction, or he requested the Bar Council of Andhra Pradesh to conduct an inquiry into the issue, because Mr. Korpad Sachinana advocate did not appear before the court even in spite of the notices given by the court. So Bar Council also, after receiving the complaint, then they sent intimation to Korpad Sachinana, who said that he was not feeling well and he was taking some treatment in Kakinada or some other place. He did not attend. Ultimately, the matter was entrusted to the disciplinary committee. According to Section 35, the Bar Council is competent to punish the guilty advocates for professional misconduct. Therefore, they have referred the matter to the disciplinary committee. The disciplinary committee will be containing a senior advocate assisted by 2 more advocates. So they have followed the procedure of the CPC, civil procedure. They sent summons to him. They have allowed him to argue. Ultimately, they came to the conclusion that he has misappropriated an amount of 14,600, which has to go to the client, that is Gutti Nagabhushnam, and he pocketed the same. Therefore, his name was removed from the list of advocates. So, Bar Council of Andhra Pradesh took a serious action. Then the matter was referred, he appealed to the Bar Council of India. Of course, Bar Council of India was also satisfied that he did not give the amount. But he showed some letters. That he wrote letters to the client, that is Gutti Nagabhushnam, to come and take the money. He showed some DDs of some 2,600 or something like that. So, and he has appeared before the Bar Council of India and stated that he was not feeling well, he has to take treatment. Due to that condition, he could not inform the client in time. Of course, Bar Council of India took a lenient view and asked the Bar Council of AP, no doubt it is professional misconduct, but the reason that he was undergoing treatment, all these things may be considered, and a lenient view may be taken. So he may be suspended from some period, not removed. This is the recommendation given by the Bar Council of India. Once again, Bar Council of AP made an appeal to the Honorable Supreme Court of India, Justice Ashok Bhan. So he has clearly stated that this is a grave professional misconduct, whatever be the circumstances. let him not be feeling well, but he has to incur the expenditure from his own pocket, not from the client's pocket. It is nothing but misappropriation. Had he been an APP, that is public prosecutor, action have been taken under professional, that is misappropriation or breach of trust, section 406 or 409 of the Indian Penal Code. Since he is an advocate, so it is only professional misconduct. Definitely it is a very grave, serious professional misconduct. So no consideration should be shown towards him. He is a fit person to be removed from the roles of the advocates. Why? Because they have stated, they have incorporated the famous case laws like M.B. Dabolkar versus, that is Bar Council of Maharashtra versus M.B. Dabolkar based Justice V.R. Krishna. He stated that the advocates should not solicit work. And another case, Harish Chandra Tiwari versus Baiju 2002. This case I have discussed with you during my interaction. So basing on these things, misappropriation of client's money is a very, very serious issue, and definitely the courts are not going to take your explanation into consideration, even though the Bar Council of India took it into the same. Anyway, ultimately, this man was removed, Korpar Sachinana was removed from the service, that is roles of the advocate, and also an amount of 5,000 were awarded as cost to the appellant, that is state of, not state, that is Bar Council of Andhra Pradesh. Good judgment, please read it, and you can, you may have to write your answer in this regard. Definitely you will get a question on this, right? Thank you very much.